Hello students, this is Dr. Bijendra Sir and today I'll talk about right to life versus right to die. Do we have right to die or one can have right to die with dignity? As we know that we have Article 21 which secures right to life and personal liberty. Now does it include right to die? Can one attempt suicide? Is suicide a criminal activity or what? Now if you look at Article 21, it talks about right to life of an individual. Now, if you look at the first time, there's a Supreme Court judgment. But before Supreme Court judgment, let me tell you certain data. If you look at WHO report, right, India has largest number of suicide or attempt to suicide. In 2018, 1 lakh 40,000 people have attempted suicide in 2018, right? But which has increased to 1 lakh 70,000 in 2026. Now, if you look at the earlier IPC, Indian Penal Code, right? Indian Penal Code has section called 309, and 309 basically criminalized attempt to suicide. Now, if you look at under the BNS, Bharatiya Nyaya Sanhita, attempt to suicide is decriminalized. However, there is a section 224. There is a section 224 which criminalizes attempt to suicide before a public officials to coerce them to do certain work, right? So it is decriminalized. Now, what about right to die according to the law, according to the court, right? If you look at Maruti Shirupati Dubbal case 1986, the first time High Court of Maharashtra High Court basically held that right to life includes right to die. Article 21 has right to life. Now it includes right to die. What does it mean? It means now this article, this section 309 could be decriminalized, right? Now why? The High Court has given an argument, or you can say that wisdom. Look at his article 2019. The court said, look at article 19. Article 19 says a right to speech, which includes right to silence. Right to speech includes right to silence. Similarly, right to life includes right not to live. Right? This was a statement given by the Maharashtra High Court in Maruti Shirupati Dubbal case 1986. Right? Now later on, if you look at the Supreme Court in P. Ratinam case 1994, right? Supreme Court basically validated the judgment given by the High Court. The Supreme Court said Article 21, that is right to life, also include a right to die. Right? Now, what happened later on, if you look at, right, Gankor case 1996, now Supreme Court has overruled its earlier judgment. Now, Supreme Court said that Article 21, that is right to life, does not include right to die. We cannot allow right to die under Article 21, because if we allow right to die, there will be misuse of it, and it goes, dignity of an individual and larger moral and ethical value. However, the court has recognized that if someone is in permanent vegetative state, right? Permanent vegetative state, right? Then right to die can be considered, right? Because we can allow right to die with dignity. That is mentioned by the Supreme Court in Gyankor case. Now look at the earlier next judgment. The next judgment is basically Aruna Sohanbag, right? Judgment in 2011. Aruna Sohanbag was in vegetative state for more than 40 years, right? Now in this judgment, Supreme Court, High Court, this is again Maharashtra High Court, held that the government must think about passive euthanasia, right? If some patient is in permanent vegetative state and even the best medical treatment cannot revive the person, then there should be right to die with dignity, right? So High Court has actually evolved the idea that is called right to die with dignity in Aruna Ramchandra Sohanbag case 2011, right? So why it has happened? Because doctor has led movement that there should be passive euthanasia in India, right? And if you look at the next judgment, right? Now look at the last judgment. So High Court has also given direction to the government. Government must think about this passive euthanasia, right to die with dignity. And you have Mental Healthcare Act 2018. Now here the law talks about that if a patient cannot be revived even by the best treatment, then we can think about some leniency for death. Now look at the next judgment, right? But before judgment, we'll talk about the 240, 241st Law Commission report. Now this Law Commission report has also argued that passive euthanasia can be given, right? Now come to the next judgment, Common Cause versus Union of India case 2019. In this judgment, Supreme Court has actually laid down the right to die with dignity, right? And Supreme Court basically held that right to die with dignity is an essential part of Article 21. Now look at Article 21. It's actually related to Article 21, where someone has a right to die, right? Or where someone has no right to die. Now Article 21 says you have right to life, right? But you have also right to die with dignity. It means if someone is in permanent vegetative state and even the best medical treatment cannot revive the person, then in that case passive euthanasia can be given. Now look at the Harish Rana, the man who actually fell down and he was in permanent vegetative state from the last 13 years. Now on 24th March, basically the passive euthanasia had been given to this man, Harish Rana. This was the first passive euthanasia case in India, right? Where the Supreme Court had actually granted passive euthanasia to this Harish Rana, right? And right to die with dignity has been implemented, right? Now in this judgment, Harish Rana versus Union of India case, Supreme Court held that a person has a right to die with dignity under Article 21, that is right to life. If a person is in permanent vegetative state beyond 12 years, then passive euthanasia can be given. And let me tell you, passive euthanasia cannot be given, right, by the recommendation of the family. No. There will be medical team that will suggest to give passive euthanasia. Now question is, what is passive euthanasia and what is euthanasia? Euthanasia is basically mercy killing, right? It is called die with dignity. If someone is cannot revive due to their illness, and if they want to die, let them die, because that death secures dignity of that person, right? So that is passive euthanasia. Now look, that is euthanasia. Now here there are different types of euthanasia. One is called active euthanasia. Now what is active euthanasia? In active euthanasia, basically a lethal injection is given, right, to the person who is in permanent vegetative state, right, whose illness cannot be revived. Now this is allowed in many countries of Europe, but in India, neither active euthanasia nor passive euthanasia was allowed. What is passive euthanasia? So active euthanasia basically gives some injection to help them to die. Now in passive euthanasia, we draw the support system. That is the passive euthanasia, right? Now in India, passive euthanasia has been allowed by the Supreme Court in Harish Rana case, and that is very important, right? It was a movement led by doctors, civil society groups, academicians and lawyers, that right to life must secure right to die with dignity, right? Someone's death should be dignified death, and that's why Supreme Court allowed right to die with dignity, that is called euthanasia or passive euthanasia. However, there is a long way to go in this movement. Now I will stop here. Thank you. See you sometime.